Good afternoon, everyone. We're going to give everyone a few minutes to jump into the webinar and we'll get started shortly. Welcome to Navigating Military Leave, what every employer needs to know. My name's Tawny Alvarez, and I'm a partner in Verrill's Labor and Employment Practice Group. Today, I'm happy to be joined by my colleagues Liz Johnston and Erik Peters as we talk about this very interesting issue. Whether you're new to military leave issues or you're looking for a refresher, understanding USERRA requirements is critical to maintaining compliance and supporting your workforce. In this webinar, we're going to provide a practical overview of key federal and some state military leave laws, including reemployment rights, benefit obligations, and employer documentation requirements. A couple of things before we jump into the content, however. For those of you who aren't familiar with our webinar series, it will be recorded and emailed to you along with a copy of the slides. This webinar has also been approved for one SHRM credit and one CLE credit for the attorneys who are in attendance. If you're an attorney, we're going to be submitting your name to the main bar for CLE credit. Also, we'll email you a certificate for your records along with a SHRM certificate. If anyone has questions during the presentation, please enter them in the Q&A box and we'll do our best to answer them in real time. With that, I'm going to turn it over to Liz to begin our presentation.
Thanks, Tawny. Good afternoon, everyone. So we'll start by taking a brief look at the agenda. Today, we're going to be covering the basics of what you need to know about military leave for employees. First, we'll talk a little bit about USERRA itself and who's covered by the protections and requirements from an employee and an employer perspective, and talk about general principles regarding reemployment obligations. We'll move into prohibited conduct and liability under USERRA, and after that, we'll cover litigation and the enforcement landscape, including available defenses, remedies, and a look at how claims are actually pursued. We'll close with a discussion of other statutory rights related to military service that you should have on your radar, and most importantly, practical recommendations and best practices that you can take back to your organization today. And jump to the next slide. So what is USERRA? USERRA is the primary federal statute that governs military leave for service members. It's been in place since 1994, and it was designed to minimize the disadvantages that can occur when service members need to be absent from their civilian careers to serve in the uniformed services. The law imposes several fundamental obligations on employers. First, employers must provide leave to employees who need service. This is not an optional leave. There's no approval process in the traditional sense. But if the employee has a qualifying service obligation, then the employer needs to provide that leave. Secondly, and this is the one that generates quite a bit of litigation, employers must reemploy those service members who return from leave, and they must do so in accordance with what's called the escalator principle. And we'll talk a little bit more about that later, but in brief, it's the idea that we put employees back into the employment situation that they would have had if they had remained actively working. Now, beyond leave and reemployment, USERRA also prohibits employment discrimination and retaliation on the basis of past, present, or prospective military service. This is a broad protection, so it's not just current service members who are protected. An applicant who discloses that they're in the reserves during a job interview, or an employee who had past service and is now being considered for a promotion, those categories of employees will also be protected from discrimination and retaliation. I also want to note another practical point here that's not on the slide, but generally speaking, USERRA is a floor and not a ceiling in terms of what employers are required to do. So many states will have their own military leave statutes that provide additional protections that are in excess of what's required by USERRA on the federal level. It could be longer leave periods, paid leave requirements, or broader definition of what covered service is under the state law. So we'll talk a little bit about state law later on, including specific to Maine. But if you have an organization with employees in other states, you will want to be aware of what state and local obligations will apply to employees there, in addition to those imposed by USERRA. Next slide, please. So which employers are covered? USERRA defines covered employers very broadly. So the statute covers any person, institution, organization, or other entity that pays salary or wages for work performed, or that has control over employment opportunities. So if you have worked with other federal employment statutes, as I know many of you have, you'll notice there's no minimum employee threshold on the slide, and that's because there isn't one. There's no minimum employee count for an employer to be covered by USERRA requirements. So functionally, USERRA will apply to all public and private employers in the US. It'll also include US employers that operate overseas. So if your company has employees abroad, USERRA will still apply to those workers. It will also apply to successors in interest, which means that if your organization acquires another company, you may inherit the predecessor company's USERRA obligations along with the workforce. And as I noted before, it's all employers, so down, even the smallest employers are going to be covered and have to comply. In addition to the employer itself, some courts have found personal liability for individuals who violate USERRA. So under the broad definition of employer, that's been interpreted by many courts, including in the First Circuit, which covers Maine, to extend liability to individual managers and individual supervisors who have control over employment decisions, mainly in the hiring and firing decision-making realm. So the practical takeaway here is that it's not just the company that's at risk for violations, but also individual decision makers are going to be covered and need to comply. And that's a really good reason to make sure that those folks and not just HR are trained in USERRA and have an understanding of what their obligations are. Next slide, please. So next we'll talk about which employees are covered. Again, this is a fairly broad group, like with employers. So USERRA's leave and reemployment provisions are going to cover any employee who's absent from work because of service in the uniformed services. But this includes full-time, part-time, and probationary employees, and there's no minimum tenure requirement. So an employee who's been on the job for one day is entitled to the same protections as a 20-year veteran of your organization in terms of what's covered. There are some limited exclusions from the category of which employees are covered. USERRA doesn't cover employees who are inherently temporary. So employees who have a brief, non-recurrent period of employment with no reasonable expectation that that employment would have continued indefinitely or for a long period. Those folks are not going to be covered by reemployment obligations. This is narrow, though. It's really designed for genuinely temporary work, seasonal work. Think like a college student hired for a short-term holiday retail position type case. Because if there was any reasonable expectation of continued employment, the exception is not going to apply on the temporary basis. Additionally, important to note that independent contractors are not covered by USERRA, but we need to be cautious here because this presumes that individuals are properly classified as a contractor. So just as we need to be mindful in terms of classification for purposes of other employment laws, we should make sure that they're truly qualifying under the applicable tests, because if they do not qualify as an IC, then USERRA could still reach that relationship. Another note here, which I alluded to earlier, is that harassment and retaliation protections are a little bit more broad than those actively taking leave. So just being mindful in terms of that, for which employees are going to be covered under which aspects of the law. Next slide, please. All right, so let's talk about what are the uniformed services and what type of service triggers USERRA's protections. So these definitions are important because they determine whether a particular absence actually falls within the statute's scope. So starting with the uniformed services themselves, USERRA covers the armed forces, so Army, Navy, Air Force, Marine Corps, Coast Guard, as well as their reserve components. It also covers the Army and Air National Guard under certain service engagements listed on the slide. The slide also notes and more, and that's because the statute's definition also extends to a number of other distinct types of service, including broadly any category of persons designated by the president in a time of war or national emergency. So the point being that there's a whole host of types of uniformed services that are going to be covered here. As for the types of service that trigger USERRA, it's also an extensive list. It includes active duty for training, and so on. We've noted the general categories on the slide, but again, the regulations contain the full extensive list of the types of absences that can qualify, which include things like absences for fitness for duty exams and funeral honors duty. Bottom line, USERRA doesn't just apply to full-blown deployments, which I think is sometimes a common misconception in how we think about the law, but it's going to apply to a variety of those shorter-term service obligations. So it's important to keep that in mind when you're handling requests for leave that might trigger application of the law. Next slide, please. All right, so let's look at the general framework for how military leave and reemployment actually work under USERRA. So first, employees must provide advance notice of their need for leave for military service, unless, there's always an exception, providing notice is impossible, unreasonable, or precluded by military necessity, which includes situations where the leave reason might be classified, so advance notice is impossible. Notably, though, the statute does not require written notice, and it does not require that the employee themselves deliver the notice. So an appropriate officer of the military branch may do so on the employee's behalf. Now, although the statute doesn't require written notice to be in writing, we do advise employers to have a clear policy requesting written notice if that's possible. But ultimately, we can't penalize an employee for not providing that when the statute doesn't require it. Employers can, however, request that the employee provide copies of military orders or training notices to substantiate the need for leave. Now, the statute itself also does not require employers to pay for the time spent on military service under USERRA. Many employers do offer some sort of pay, whether it be a matter of policy or pursuant to, say, a collective bargaining agreement, if one's in place. So if that's you, you should be sure to apply those policies consistently among employees that are requesting military leave. Also, again, noting that some states require paid military leave, so you'll need to be mindful of those obligations if they apply. One other thing to note here is that if the leave is unpaid or partially paid, employees can choose to use their accrued vacation or PTO during military leave, but they can't be required to do so. So something to be mindful of for your policies. In terms of reemployment rights themselves, to be eligible for reemployment, the employee needs to satisfy several conditions. So advance notice must have been provided, as we just talked about. And also the employee is cumulative military service with that same employer must not exceed 5 years. But this 5-year limit has significant exceptions. So certain types of involuntary service or service during national emergencies, as well as other categories, are actually excluded from that calculation. So in practice, many service members who appear to exceed the 5 years will still qualify once the exceptions are applied. So it's important not to assume that a long deployment history automatically disqualifies an employee from additional leave. We need to look at the particulars of each situation. The employee also must return to work or submit an application for reemployment in a timely manner in order to come back, and those applicable deadlines depend on the length of service that they took. So just by way of example, if the service was fewer than 31 days, the employee needs to come back to work on the first regular day that's at least 8 hours after they get home. It's a longer employment or a longer period to submit an application for reemployment for longer periods of service. Again, with exceptions for if that application is in the window is impossible or unreasonable. Another condition of reemployment is that the employee must not have been separated for disqualifying conditions from the service. So a dishonorable discharge, for instance, would disqualify them from reemployment. And finally, there's additional exceptions, including if the employer has a significantly changed circumstances, such as if there was a RIF or a significant change to operations that would impact reemployment. Again, applying that escalator principle, which we'll talk about, as well as undue hardship defenses based on the particular circumstances. And next slide, please. All right, and then there's a few additional employer obligations that I wanted to talk about with respect to reemployment. USERRA requires more than simply holding a position open and offering it back when the service member returns. So as I've alluded to, employers must apply what's referred to as the escalator principle upon the employee's return to work. So this means that employers need to look at the time of the reemployment, what position the employee would have been in had they not taken military leave. So if they had continued working. So if the employee's peers have received raises, promotions, or had accrual of seniority while the service member was deployed or on leave, that returning employee is going to be entitled to the benefit of those advancements. So that can include things like seniority-based benefits, like PTO categories that are triggered by seniority, promotions, raises, and the like. Again, what would have happened had the employee not taken leave? One thing to note here is that we generally think about the escalator principle going up and resulting in upwards mobility, but it does go up and down. So depending on the circumstances, which again need to be evaluated really carefully, but the escalator might actually cause the employee to be reemployed in a lower position or transferred to a different facility or even laid off if that's what would have happened if the employee had remained actively working. But this is a really fact-specific analysis that should be done, especially when an employee is returning from a longer period of an absence. Second point here is that employers need to reasonably accommodate disabilities incurred during or aggravated by military service. And it's a little bit further than just our standard ADA obligations. So under USERRA, the employer needs to make reasonable efforts to accommodate a disability so that the employee can come back in that reemployment position. But if the employee can't perform that position with a reasonable accommodation, the employer needs to employ that individual in a position of equivalent seniority status and pay, even if it's not the one that they would have come back into. So we have to look at that secondary position. And then there's a third step, which if that's not possible, the employer needs to put the employee in a near approximation of such position. So it's kind of like a little bit of a waterfall obligation that's unique to USERRA and is more protective than the ADA as we traditionally apply it. Third point I want to make here is regarding training and retraining. So employers do have an obligation to provide training or retraining to qualifying employees coming back. And this really applies if the job has changed while the employee is away. So maybe there's new software in place or new certifications required for a position. We can't simply say that the employee is no longer qualified for the role, but the employer needs to invest in getting the employee up to speed on those new requirements. And finally, reemployment needs to be done promptly. So the statute and regulations generally contemplate that reemployment occurs within 2 weeks, absent unusual circumstances. Again, another exception, but it is narrow. So, it really means if there's significant circumstances that are preventing reemployment, that might be an exception in the 2 weeks, but it doesn't necessarily mean 2 weeks and we're still processing paperwork. We need to make best efforts to get that done in 2 weeks, absent something exceptional. So with that, I'll turn it over to Erik to talk a little bit more about USERRA and the non-discrimination elements.
Thank you. So as you probably figured out from Liz's portion of the presentation, USERRA has a very broad application. So I'm going to talk a little bit about discrimination and retaliation claims under the statute. So It prohibits discrimination in the initial employment. I think Liz mentioned it applies to applicants. It prohibits discrimination when somebody is talking about being reemployed by your company. It prohibits discrimination when you're talking about retaining somebody versus firing them, and when you're talking about promoting somebody. You can't discriminate against them on the basis of their uniformed service. And there's also sort of a catch-all in that last bullet. You'll see that prohibited conduct also applies, or USERRA also prohibits discrimination with regard to any benefit of employment. And if we can go to the next slide, we talk a little bit about what that means. And again, super broad definition and designed to be super broad. It's a statute of wide application, a policy decision that we want people who are in the military and fulfilling their military obligations not to be disadvantaged by it. So the benefits of employment include, you can see there the bullets. I won't read them for you, but I highlighted the first one, any employer policy, plan, or practice. And Liz sort of touched on this a second ago when she was talking about seniority based benefits and their accrual and how USERRA affects entitlement to that. But one of the benefits of employment that you cannot discriminate against is, and you can see this first bullet is incredibly broad: advantage, profit, privilege, gain, status. I mean, that's pretty much everything you would think of, or is designed to be drawn broadly, that would apply to being prohibited from an employer discriminating against. Also, unsurprisingly, you can't discriminate on the basis of uniformed services when it comes to someone's pay, including their severance pay, or just another catch-all. To the extent that employer policies or plans didn't apply to it, you can't discriminate when it comes to pensions, health plan, ESOP, insurance coverage, things like that. And then other things that are incidents of the employment relationship, like vacations and like an employee's ability to select their work hours and location of employment, if that's something you offer. Again, cannot discriminate against people for their work in the service as a result on any of those things. If we go to the next slide, please, we'll talk a little bit about retaliation. Unsurprisingly, again, very broad. Can't retaliate against someone who is trying to enforce one of USERRA's protections. So in other words, I go to my employer and say, I'm a vet or I'm in the Guard and you can't do this, and somebody retaliates against me for basically asserting my rights against USERRA, that can be a claim for discrimination under USERRA, but also not only did you discriminate against me when I complained about it, you retaliated against me. Similarly, you can't retaliate against somebody who testifies or makes a statement connected with an enforcement proceeding, potential whistleblower, potentially somebody who's connected with the case. So let's say I'm a vet and I have an enforcement proceeding under USERRA and I ask Tawny and Liz to be witnesses. They can't be retaliated against, even if they're not in the uniformed services. They can't be retaliated against by helping me enforce my rights under the statute. Similarly, can't retaliate against somebody who assists or participates in an investigation. And again, you can't retaliate against somebody for exercising a right provided by USERRA. It's pretty familiar to those of us who have had to deal with employment discrimination matters and retaliation matters, especially under the Whistleblower Protection Act, or it's not uncommon for a lot of us who are involved in employment discrimination matters to see a fact pattern where someone complains about, for example, sexual harassment, and then later claims that they were retaliated against for the complaint. USERRA has a similar dynamic. You can, as an employer, you can be sort of punished for the core crime, which is discrimination, but you can also be punished if you retaliate against somebody. So sort of the crime, discrimination, and the reaction to the crime, retaliation. If we can move on to, and one other thing before we move on, as I alluded to a second ago, this protection against retaliation applies regardless of whether the individual has performed any military service. So again, that hypothetical I gave where I'm in the military, I ask Liz and Tawny, who aren't in the military, to help me out in my USERRA action. They do so. even if they're not in the military, they can be afforded protections under the statute. All right, let's talk about when an employer can be liable under the statute. So this part of the presentation is sort of about how litigation works with regard to USERRA. So if I'm a USERRA claimant, I've got a discrimination claim, I've got a retaliation claim, what do I need to show? What do I need to prove? So I have to show that the employer's action was either motivated by one of those bullets or that one or more of them was a substantial factor in the adverse employment action that happened to me. So it has to be based on my membership or even my application for membership in a uniformed service. Hey, I'm an employee here. I'm an employee at Vero Dana. I'm applying for the National Guard. My application's still pending. I'm discriminated against, even if my application hasn't been acted on and I haven't gotten in yet. There can be a cause of action under that. Unsurprisingly, a liability also attaches where an employee actually performs their service or an obligation or performs an obligation for their service. Again, as we talked about just a second ago, if somebody tries to enforce a protection they're afforded to them under USERRA, then you can be liable for discriminating or retaliating against them. And a couple, just to follow up that last slide, testimony or statement made in connection with a USERRA proceeding can be a situation where liability attaches, assisting, participating in an investigation, or exercising a right. So I want to just touch on a couple of things before we move to the next slide about a little bit of nuanced stuff related to liability and sort of burdens of proof here. So I mentioned that the USERRA claimant, the person bringing a claim under the statute, has to show either the employer's action was motivated by one of those things in the bullets or that it was a substantial factor in the discrimination or retaliation. So case law tells us that military service is a motivating factor for an adverse employment action if the employer relied on, took into account, considered, or conditioned its decision on the person's military-related absence or obligation. So pretty broad. And here, interestingly, there are a lot of similarities between the employment discrimination laws that a lot of us work on a regular basis, but a lot of important distinctions. One of them here is that the plaintiff only has to show that the military service was a motivating factor in the adverse employment action. Unlike Title VII and a lot of the employment discrimination laws that we're familiar with, the plaintiff doesn't have to plead or even prove that they're objectively qualified for the job at the beginning. The lack of qualifications is relevant, but it's actually the employer's burden. It's an affirmative defense that the employer has to plead and prove rather than something that the plaintiff has to prove, which is different from what we see with Title VII, the ADA, and other kind of more commonly used employment discrimination statutes. Okay, let's look at some employer defenses under USERRA on the next slide, please. All right, so the two big kinds you see, the two big types of defenses you see in these claims are where the employer says one of two things. I would have done this anyway, regardless of your USERRA protected status. So there's sort of two ways you can argue this. One, you argue, well, even if it played a part, I would have done this anyway, even if you weren't in the military, even if you didn't have whatever the USERRA qualifying reason is. And that's a dual motive case. The pretext cases are more kind of similar to what we're used to seeing in employment discrimination cases, where the employee has the burden of proving that they were qualified at first, and then the employer has to come back and show a legitimate non-discriminatory reason. These pretext cases, the second bullet, the agency, the employer argues that they took the adverse action for a legit reason and not because of the military service, that the military service had absolutely nothing to do with it. So we're happy to answer any questions. Obviously, we wanted to just sort of keep this as free from legalese as possible. There's a lot of case law on all of this stuff and a lot of stuff some cases that really explain things pretty well. If any of you are interested and you reach out to us afterwards, to the extent that, like I have a bunch of case law sites with my stuff, If you want sites, if you're an employment law geek like us and want to read this stuff, go nuts. We're happy to give you the sites. All right. We talked a little bit about defenses here. What are the limits on those defenses? And that's on the next slide. So a court will look at, or an administrative agency, and we'll get to that in a second. There's a whole range of forums in which people can bring USERRA claims. But what the reviewing agency or court or jury is going to look at is whether the reason for the adverse action is intrinsically tied to the employee's military service. And now, for example, and these are all taken from cases that interpret USERRA. When is something intrinsically tied to the employee's military service? Well, how about when somebody is excessively absent and it's because they've been deployed? So that's, obviously intrinsically tied. An employer can't use excessive absences to justify termination when the reason for the absences is the military obligation. Similarly, although you can hold USERRA qualified employees to the same standards of conduct and performance, you can't punish somebody if there's a defect or deficiency in conduct and performance that's related to them fulfilling their military obligations. And similarly, and I just pulled these three because I thought they were sort of interesting illustrations of this point. An employer can't time disciplining or terminating an employee to try to avoid providing the employee with the benefits of laws that protect veterans, including USERRA. And what I mean by time, and the reason why that's in quotes, is you can't do something like, oh, you're about to apply to, be in the National Guard. Your application's going in tomorrow. I'm going to fire you today, so that way you don't get the benefit of USERRA. You can't, again, this is a statute that's designed to be very broadly applied, very generally applicable. As Liz mentioned, it applies to all employers, unlike most federal employment discrimination statutes, which you have to meet a certain threshold. So it's a tough statute to get around, and the courts make it tough for a reason. So know that going in, that if you are an employer, you have very broad obligations under the statute, and there are not a lot of exceptions to it. All right, so we've talked about how you bring a claim. We've talked about how you defend a claim. We talked about the limits on defenses to a claim. What can you get if you win a USERRA claim? So let's go to the next slide and we'll talk about everybody's favorite topic, money. So under USERRA, a successful claimant could get their lost wages and benefits. You fired me in 2024 for a reason that was illegal under USERRA. I win my case. I'm entitled to front pay, back pay, all that stuff that we're familiar with through our employment discrimination statutes that we work with regularly. There's also a provision allowing employees to get liquidated damages, either 50,000 or an amount equal to lost wages, benefits, and interest for willful violations, whichever of those two things is greater. And again, a little twist on the employment discrimination statutes that we're all familiar with. Attorney's fees and costs are mandatory for prevailing plaintiffs under USERRA. Generally speaking, if you're a prevailing plaintiff under Title VII or the ADA or the ADEA or something like that, you'll get your fees, but it's not mandatory that you get them. And you have to jump through a lot of hoops. You have to file a fee application with the court. And in certain circumstances, the court won't, certain rare circumstances, the court won't give fees to a prevailing plaintiff. Here, there's no discretion. They have to provide them if the plaintiff wins. Okay, so those are monetary damages, monetary relief. Let's go to the next slide, which is equitable damages and equitable relief. And
Eric, just to note, like as to your monetary damage, there are a lot of firms that only do this type of plaintiff's work because the requirements are so specific, right? If an employer does make a misstep, it's an easy case for a plaintiff's counsel to make. And I think we're lucky that that type of litigation hasn't hit Maine, but on the West Coast, in California, there are plaintiffs' law firms who only do USERRA litigation because it's such easy money. So understanding that it is really important for everyone on the webinar, that we're lucky we haven't seen that here locally, but there's a tidal wave likely coming.
That's a great point, and to sort of take it a little bit further, Tawny. One of those for those of you who haven't had the pleasure of being involved in litigation, especially being sued under a statute like Title VII or some of the wage and hour laws, where attorneys' fees are an option for successful plaintiffs. That's a huge driver in the litigation. And as Tawny suggested, one of the reasons that firms can take cases like this is because of, and take them for free, is because of this mandatory attorney's fees component. So you can go, if I'm a vet who thinks my rights have been violated, this law firm can come to me and say, "Hey, sign up. You don't have to pay us anything. We're going to try to get our fees anyway." So that's for those of you who've been involved in litigation, you know that attorney's fees or the potential right to attorney's fees is often a huge driver in cases and settling cases and frankly prolonging cases. So that's yet another thing that you have to take into account here, along with, as Tawny said, this is a pretty technical statute, and it's got a lot of kind of weird little nuances that you wouldn't necessarily think would be the case. But also, a lot of people, frankly, aren't all that familiar with it. It hasn't, doesn't come up all that often. So an easy case to, or an easy statute to make a mistake on, and then all of a sudden you've got a plaintiff's lawyer knocking at your door saying, "I want this huge amount of money. That includes my attorney's fees," which, by the way, are only going up the longer you litigate this matter. So it's again, it can be the penalties for non-compliance are severe, can be severe, and so that sort of brings us back to this slide, which talks about, in addition to money, the court or the administrative agency can issue what we call equitable relief, which is essentially non-monetary damages, like an order ordering an employer to comply with USERRA, including an orders reinstating somebody back in their job. Temporary or permanent injunctions, for example, on violating the law, on separating someone from their employment, or TROs to that effect. And if the employer, things really go south for the employer, you can be held in contempt, which typically results in happens when somebody gets an order issued against them, doesn't comply with it. As you can imagine, that makes judges pretty salty. And so when you don't comply with an order, a lot of times you can get hit with a motion for contempt. Okay, so I mentioned earlier there are a variety of forums in which parties can bring USERRA claims. If we go to the next slide, please. Thank you. So USERRA as a whole is administered by the DOL, and it's got a separate department of the DOL called Veterans Employment and Training Service, DOL Vets. It's enforced in a couple different ways. There's the Merit Systems Protection Board, which handles claims by federal employees. DOJ will get involved in certain cases involving private employers, or in cases where the state or local government is the employer at issue. There's also a private right of action under the statute, and by that I mean you can go out and hire a lawyer. All right, so one last thing before I throw it over to Tawny. If we go to the next slide, and this is another little kind of weird quirk about USERRA, there's no statute of limitations for claims that accrued in the last 17 and a half years. There's just no statute of limitations, which makes it, and there's another thing that sort of makes it nice if you're a lawyer who represents USERRA claimants. You don't have to worry about blowing the deadline. The other, and I don't know if there are that many pre 2008 claims left, but to the extent that there are any, the statute of limitations for them is told while a service member is doing their actual military service. All right, so that is sort of litigation under USERRA, a little bit of an overview. Let's switch over to Tawny, who's going to talk about some other statutory rights that are related to military leave.
We're going to talk just briefly, in a little bit more detail about the administrative rights element specifically. And so, there's all these different avenues, and I feel like this whole entire presentation is a situation where the exception subsume the rule, right? And exactly what Erik said earlier, it's so easy to kind of make these, minor mistakes that could have large consequences or could have minor consequences, but there's just a multitude of ways for that to be responded to. And understanding that military service members have a multitude of different options as to how they handle it and what that looks like is important. They could use the employer support of the Guard and Reserves Omnibud service. It's called the ESGR service, and that's like an attempt to mediate the claim. And so the ombudsman would speak to the employee, then they'd reach out to you as the employer, see if they could resolve the matter. There's no requirement, however, that the employee use that service. Instead, they could immediately go to the DOL vet's office. They could choose to use the ombudsman service first, and if they were unsuccessful, then go to the DOL vet's office, but no requirements that they follow each of these steps. And when they go to the DOL vet's office, they're going to make their complaint in writing or electronically, provide the name of the employer and the summary of the alleged violations. And from there, DOL is going to investigate it. They have subpoena power, both individually as an agency, and they can go to the federal courts and get a federal court subpoena. And they're going to attempt to resolve the matter. If they're unsuccessful, then as Erik mentioned, you then potentially are going to office of Solicitor General or the DOJ for litigation on the claimant's behalf. If, however, DOJ is like, nah, we're not interested in it, don't worry, the case doesn't end there. We can go to the next slide. As Erik discussed, there's this private right of action, and we have attorneys who are waiting on the sidelines to take these cases because of all of the benefits that are involved and the ease of obtaining attorney's fees. Unlike Title VII and so many of the retaliation claim, whistleblower claims, there's no requirement for administrative exhaustion. So you could make an error and the next day you could have a federal court lawsuit filed against you as a result of that error because there is no obligation to go through any administrative process. Similarly, for those of you who might be employed with state agencies or HR offices at state agencies, DOJ can sue state agencies as can an individual plaintiff. So while there, oftentimes is arguments concerning sovereign immunity, there's no sovereign immunity argument that's at play in these cases, and the state or local municipality will be required to kind of answer for their failure to follow this statute. Let's jump to, you have employees who are going out on military leave who are serving their country in one way or another. There's also all the people who are still at home who are supporting our servicemen and women, as well as the veterans who are coming home after their service, and you employ those individuals. So the first one we want to talk about is military caretaker leave. It's available under the FMLA for our employers who have 50 or more employees within a 75-mile radius, as well as, there's state FMLA obligations too, depending on the state of operations in which you're in. The qualifying reason for the military caretaker leave is to care for an injured service member, which is a different definition than what we find as a family member under the normal FMLA caretaking responsibilities. And here, an injured service member would be a spouse, a child, a parent, or a next of kin. A next of kin, the best way to describe it would be nearest blood relative. That could be a niece, a nephew, an aunt, an uncle. It's really the closest level of familiar relationship to the covered service member, unless the covered service member has specifically designated an individual to serve as next of kin for military caregiver leave purposes. So it could be a third party who has been designated as next of kin, very similar to the close familiar relationship that we see under the main Paid Family Medical Leave Act. Different as well from our regular FMLA for birth or care for a child or your own serious health condition or caring for the health condition of a family member. Here, an individual is entitled to 26 weeks of unpaid leave in a 12-month period. When we talk about what service members are covered, it is different from the definition Liz gave earlier about what USERRA covers. So here it would be a current member of the armed forces, which includes National Guard or reserves. And that individual must have a serious injury or illness. And when we talk about what that is, they have to be undergoing medical treatment, operation, or therapy. They have to be in outpatient status, or they have to be on the temporary disability retired list. It is broad, however. It's not just kind of immediate current members. It's also veterans of the armed forces if they served within the last 5 years and are still undergoing medical treatment, recuperation, or therapy as a result of serious injury or illness. There is an exception, however, to that, similar to USERRA, lots of exceptions, right? And that excludes dishonorable discharges. An illness or injury is also different from what we generally see, the definition of a serious health condition under the FMLA. It has to be incurred in the line of duty while on active duty. So if they were on inactive duty and there was an injury, that wouldn't count. Or it has to have existed before active duty, but was aggravated in some way by service in the line of duty and resulted in that person being determined to be medically unfit to perform their duties. For a veteran, someone who's not in active duty, it would have to be an injury or illness that occurred in the line of duty while on active duty, so previously, or existed before and was simply aggravated by the active duty service, and that it manifested. It could be that it takes 4 years to manifest, and that would still be covered for military caregiver leave obligations. Um, an employer in this situation can seek authentication and clarification of documents, the FMLA form itself, but they generally cannot seek recertification or a second or a third opinion. Unless, and this is where like when I say the exceptions in this area of the law really subsumes the rule, you can ask for a second or third opinion if the healthcare provider who issued the FMLA documentation was not a Department of Defense healthcare provider, was not a Veterans Affairs healthcare provider, or was not a private healthcare provider who is a member of Department of Defense TRICARE network of authorized private healthcare providers, or a Department of Defense non-network TRICARE authorized private healthcare provider. This is certainly an area of the law where we do recommend contacting your counsel if you have any questions because of how specific the rules are and how different it is from a regular FMLA request, similar to any of the USERRA elements more generally. If we jump to the next slide, we'll also talk a little bit about exigency leave. So there's the right to federal FMLA exigency leave, which is that normal 12 weeks of leave. It would be unpaid under federal law. And it applies to the need to cover a variety of situations once an employee's spouse, son, daughter, or parent who is a member of the military is either on covered active duty, on call to covered active duty status, or has been notified of impeding call or order to covered active duty status. And covered active duty is a member of the armed forces in which the deployment will be to a foreign country, or a member of the reserves and their duty during deployment will be to a foreign country unless it's under a federal call or order to active duty in support of a contingency operation. A qualifying exigency is extremely broad. And it includes many of the things that may be necessary in order to prepare for someone to go out on active duty. So it could be things such as official ceremonies or events or programs sponsored by the military, changes in schedule needed to arrange or provide childcare, or cover school activities if the qualifying member of the military has a child, arranging for alternative child care, um, providing urgent or immediate child care needs if the individual had sole or primary caretaking responsibilities previously, enrolling in or transferring to a new school or daycare program, attending counseling services, spending time with military members who are on short-term temporary rest and recuperation leaves during active deployment, attending post-deployment activities such as ceremony, reintegration briefings, addressing issues related to injuries or deaths regarding a member of the United States military. So all of those qualify as exigencies, and understanding that it is really important. There's also additional kind of examples or situations where if it's the parent, the employee's parent, and the parent for a period of time is incapable of self-care, whether or not that's to help them to doctor's appointment, to provide specific care, to work with healthcare providers, that would also be a qualifying exigency. Um, as to the certification requirements, the first time that qualifying exigency leave is requested, the employer may request a copy of the service member's active duty orders or other documentation, but it's just that first time. There's some situations where the employer may also require certification for particular situations, and that would be if there's other facts that are contrary to the understanding. But you can ask for data and information concerning when the qualifying exigency will start and end, frequency and duration, and then if there are third parties involved, you can ask for the contact information for those. Um, you can also, if it's a rest and relaxation leave, you can ask for a copy of the military member's rest and recuperation orders. But understanding that there are these limitations on the certification requirements is important with exigency leave. Let's jump to the next slide and just talk briefly about the state of Maine and family military leave. And this is found under 26 MRSA 841, family military leave. And it only applies to employers with 15 or more employees, and it's a Maine statute. It provides 15 days of unpaid family military leave, and that's per deployment. There's benefit protection during that time, similar to FMLA leave, where you have to continue to provide the employee with the same benefits that they would have received had they been actively employed. And there's also anti-retaliation and anti-interference provision there. This statute itself provides a civil right of action, and the relief available is injunctive relief. So this isn't a statute that we see a lot of litigation surrounding because there are no fees associated with it. The only thing that an employee would be able to obtain as a result of the litigation is an order requiring the employer to comply with the statute. At the same time, just because we don't see a lot of litigation or case law surrounding it, it's still really important to understand that these obligations exist and making sure that you are providing that leave to employees. Let's turn to our final content slide, and that's policy best practices, right? So we've now spent the last 55 minutes talking about USERRA and other military leave laws itself. Takeaways, I hope you have a number of them with the understanding that oftentimes the exceptions subsume the rules in these situations. when we have something like that, it is important to make sure that we have policies and practices set up. I've divided it into two kind of categories, your external handbook policy. And when I say external, I mean the policy handbook that you provide to your employees, your personnel policies, what all of your employees will read. It's important in that document because all of the exceptions sometimes are in play. We don't want a 7, 8 page policy, right? Provide general information about the employee's rights, responsibilities, the employer obligations, right? Specifically, eligibility, how long it's available, what they can expect as to compensation and benefits during the leave, the reemployment rights, the anti-discrimination and anti-retaliation obligations, and then have who they should contact to really understand the meat of what their rights are. Recognize and understand that when they're in deployment, there'll be resources that will be provided to them, which from whatever arm of the uniform service that they're serving in, that is going to be informing them of their rights simultaneously, right? So making sure that we're appropriately communicating it with our employees is paramount. Then, and this is what I highly recommend, is having an internal HR operations policy that really sets forth, the timeline for when things need to be communicated. This is a situation where we have employees who could be out of work for extended long-term periods of leave, 5 years or more in many cases. So there has to be a way in which this data is appropriately captured. And for smaller employers, that can be difficult. If you're an HR department of one and you win the lottery, I used to say hit by a bus, and everyone said, let's use something a little happier, Tawny. So it's not gray cloud Tawny. It's like happy win the mega bucks, and decide to leave employment. Making sure that whoever your successor is aware, hey, these people are still employed. Don't just terminate them. Here's the date they went out on leave. Here's so having a process and procedures in place is really important. Have checklists available that you're using. Make sure you communicate with your on-the-ground managers as to keywords and phrases that they're going to want to bring to your attention, both as it relates to USERRA and as it relates to other military leaves. I know that there's been a ton of information over the course of the last hour, but we'll go to our last slide, and I think I'll just say thank you all for being here with us. If you have any questions, again, you're welcome to use the Q&A function right now. I don't know if Erik and Liz have any final parting words, but we appreciate your attention to this really important topic.